current form, courts martial are not in a position to deliver a free and fair trial as guaranteed under Article 28(1) and 44 of the Constitution of the Republic of Uganda. I would forthwith suspend all operations of courts martial, save for the hearing of disciplinary matters pertaining to serving officers. All convictions and sentences passed by courts martial would be suspended. A pathway would be put in place to ensure that all citizens hitherto convicted and sentenced by the military courts martial have their convictions and sentences subjected to judicial review before a civilian court of competent jurisdiction to determine whether the convict received a fair hearing and impartial prosecution. This order would not apply to persons who were convicted and sentenced by courts martial and have already served their sentences. For efficiency and proportionality purposes, I would invoke the doctrine of prospective annulment on decisions, orders, and sentences of courts martial which have already been served. That notwithstanding, I would order that all cases currently pending trial before the courts martial be suspended forthwith. An injunction don't issue restraining the instigation, reopening, or continuance of the respondent's trial before the general court martial or other courts martial. I join issue with the recommendations or advisory orders proposed by the Honorable the Chief Justice. To these, I would humbly wish to propose a status of the offender determination in civilian courts. When the necessary legislative amendments have occurred, it should be imperative that prior to subjecting a civilian or person considered so by color of rights before future courts martial, a status of offender determination be made to the High Court of Uganda. Such investigation should be subject to the highest scrutiny, akin to extradition proceedings or movement of jurisdiction. The courts would have to be satisfied by an explicit demonstration that the interests of justice cannot be served in the ordinary course of judicature. This standard would be applied to all matters in review. I further would propose to refer the proposals for amendments raised in Second Lieutenant of 1 Ambrose versus Uganda, Supreme Court Criminal Appeal number 48 of 2021. The Supreme Court found that the UPDF Act in its current form creates a separate judicial system which has no recourse for appeal or judicial review to superior courts. The court called for legal review.
Justice Elizabeth of the judgments. You will please bear with her. I think she's got a little cold. She's patient.
The Roman Empire's legacy of military discipline is notable for its extreme punishments such as dissemination, where 1 in 10 soldiers were executed for collective disobedience. Collective disobedience included such offenses as mutiny, and mutiny included offenses like tree-sitting, sabotage, among others. Tree-sitting meant that the rank and file of men in the mutiny would choose to sit under a tree and not do any work. Specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with the discipline and regulation of the armed forces. The Constituent Assembly, while debating the setup of the army courts back in 1992, envisaged military courts as special purpose vehicles to enforce discipline within the military and ensure that there was a battle-ready and disciplined force anytime they were needed. Leading up to the enactment of the 1995 Constitution, the CA did not support granting army jurisdiction over civilians. The Constituent Assembly laid emphasis on the necessity to guarantee a free and fair trial and other due process rights and critical need for the independence of the court-martial, stressing that their role be limited to handling military-specific offenses against military personnel. The General Court-Martial, as currently set up under the UPDF Act, is fundamentally incompatible with the constitutional safeguards for a fair hearing and is unconstitutional, and therefore its exercise of judicial power is equally unconstitutional. To re-echo the words in Curry, the court-martial system structure, including the convening authority's power to prefer charges and select court-martial members and report back to superiors, is fundamentally at odds with the due process and constitutional in the civilian justice system and even unjustified in the military justice system. Having found as above, I hereby make the following declarations.
First and foremost, it is not a win for me, Michael Kabaziguruka. It is a win for the people of Uganda. It is a win for the democracy-seeking forces in this country, because the GCM has hitherto been used as a tool to fight anyone that is opposed to the bad leadership of General Yoweri Museveni. So I want to thank my legal team, led by the able Honorable Medal Lubega Segona, Councillor Samuel Moizi, Councillor Alaka, and of course the Lord Mayor, Salongo Elias Lukwago, for the battle that they fought so hard to reach here today. When General Museveni sat with some members of the IPOD back in 2016, he informed them that Kabaziguruka is finished, that I must finish Kabaziguruka. I was in jail at the time, but I read an article in the Observer where he says I tried to assassinate him and that therefore my end was near. So I thank Honorable Segona, who reached out to me and informed me and took over the responsibility of standing with me as my counsel in these matters. Of course, when I was arraigned before the GCM, I refused to accept their jurisdiction over me. And I remember at the time, I told the chairman, Lieutenant General Andrew Guti, that he was not fit to be a magistrate of any sort, and that therefore he had no authority to try me for an offense whose maximum sentence is death. He threatened to hold me in contempt of court, but I held resolute, I held steady, and I said, no, you have no jurisdiction over me. I even told him that I would represent myself in that GCM, that I did not recognize it as a court of law and that I had no business bringing a lawyer there. And I did not. I opted to file petitions in the civil court of the in the civil division of the High Court, in the criminal court, and then finally to the Constitutional Court. And here we are today, where the Supreme Court of the land declares here today that the GCM is no more. It is finished. Well, ensala ya kooti olwaleero njaniriza era ensalawo si yange ng'omuntu kinoomu wabula ya bannayuganda ffenna. Emabegako mu mwaka gw'2016 mujja kujjukira nti nakwatibwa n'envunaanibwa mu kkooti ey'ekinamagye GCM, General Court Martial, nga nvunaanwa omusango gw'okulya mu nsi olukwe. Emisango gye nawakanya nga nkimanyi bulungi nti nze sibeerangako munnamagye. Sisabanga nako, waliwo kuba nti nali nsabyeko ne bagaana, naye sisabanga nako kwegatta ku magye. N'olwekyo tewali nsonga yonna lwaki baali banvunaana mu kkooti y'amagye. Nagaana okukkiriza okuwoza mu kkooti yaabwe, era ne nsaba balooya bange tufayiringe constitutional petition tetwafayiringa era ne tuwangula. Gavumenti ng'eyita mu ssaabawaabi waayo yawakanya ensalawo ya Constitutional Court n'ejulira mu kkooti ensukulumu mu ggwanga lino, Supreme Court. Era olwaleero ndi musanyufu nti kkooti eno esaze omusango guno mu mazima n'obwenkanya, nga yeesigamye ku tteeka constitution ey'eggwanga lino, era esaziza amazima n'obwenkanya. Nti olwaleero Mwami Museveni gy'abadde akozesa okunyigiriza naddala abo ab'oludda oluvuganya ng'abavubuka ba NUP abamazeeyo emyaka kati kumpi 4, Dr. Besigye nga si gwe mulundi ogusoose, guno ndowooza gwakubira era ng'ali mu court martial. Era nkubiriza bekikwatako mu bunnambiro abantu bonna abakyali mu kkooti, abakyali mu makomera ag'enjawulo bateebwe bunnambiro. Si kyakukolebwa nkya oba ku bbalaza, wabula balina kukikola ssaawa eno nga kkooti bw'eragidde.
LOP, you should be having something to tell us, really, given that so many of your supporters are in